According to Ms. Wilson's, she observed the defendant put on a jacket valued at $46.39 under his jacket and conceal Dickies socks valued at $9.98 and a pair of Reebok boxers valued at $11.97. The defendant went to the self-checkout and only paid for gum. At that point, the defendant passed all points of sale. At that point, the defendant was arrested, Your Honor. Those are the facts of the case. You have the recommendation.
Mr. Lott, I understand that around that time you were like 19 or 20. But sir, I don't know whether it was the thrill or whether you just decided you need a go out outfit. What was going on? But we're not gonna do that anymore, are we?
I was just young.
I know. Let's not do that. And then discourage anybody else you know from doing that because it's not worth it. Because first of all, let me just let you in on a little secret. Walmart got more cameras than this courthouse.
Yeah.
Everything you do in a Walmart is on camera. And when y'all think y'all skip scanning and there's a camera looking at you inside the machine, right? It's not just the lasers. There's an actual camera looking at you inside the machine. So if you're standing there thinking that you skip scanning, there's readers that read the codes like right next to the machine. You can't, they know you're stealing.
Yeah.
It's whether they decide to prosecute you or not, but they know you're stealing. Okay? You're not getting over on anybody. So I'm going to accept your plea of guilty. I'll sentence you to 12 months probation, a fine in the amount of $200. The $200 fine is going to be $298 total with the surcharges, 40 hours of community service. Go do something good for a good organization. There are a lot of them out there. A theft prevention course, and you're not to go back to the Walmart at 29. Upon completion of all of the special conditions of your probation, all of the conditions asserted are special. Upon completion of all of the special conditions, then your probation can terminate. All right, but don't go up in these people's stores stealing. We're doing better than that, right?
Oh, yeah, I'll do that one.
Okay, we've grown up.
7
Good. Now,
is simple battery, and we're going forward only on the criminal trespass.
all right, so that'll be no problem. Okay, and on the case 2025 CR 00546. For battery family violence count 1, battery count 2, simple battery family violence count 3, and simple battery count 4.
Judge, he's pleading guilty to count 1.
Okay, counts 2, 3, and 4 will merge. All right. So, Mr. Dixon, on each of these cases, on each of these charges, by entering pleas of guilty on the case in 2024 CR 02178 by entering a plea of guilty to count 1, simple battery, family violence. On the case 2025 CR 00537, a guilty to criminal trespass on count 1. And case 2025 CR 00546, guilty to battery, family violence. The remainder will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. If I could just have one moment, just want to make sure I have all the cases in front of me.
It's a lot of them.
Make sure I get the right information. In case 2024 CR 02178, on April the 4th, 2023, officers responded to 1018 Gardenwood Drive, located here in Clayton County, Georgia. When officers, in reference to a domestic disturbance, when officers arrived on scene, they made contact with 2 individuals, one being the victim. Is it Nyjaya, Nyjaya Jones, Jones, and also the defendant before you, Mr. Dixon. Officers learned during the course of their investigation that the defendant, based on the verbal altercation, it did turn physical when the defendant did pick up the victim, Miss Jones, and throwing her aggressively. Officers did not observe any injuries at the time. Those are the facts of the case, Your Honor. The state's recommendation for count 1 is 12 months to serve. Count 2 will merge. In case 2025 CR 00537, on January the 21st, 2024, officers responded to 1018 Gardenwood Drive in reference to a domestic disturbance. This incident did occur in Clayton County. Officers did speak with the same victim, Ms. Jones, who indicated there was a verbal altercation and that the defendant did take her iPhone, took both of her iPhones, and refused to allow her to call the police. Those are the facts of the case. The state's recommendation is 12 months to serve. In the last case, that is 2025 CR 00546. On February the 15th, 2024, officers responded to 1018 Gardenwood Drive located here in Clayton County, Georgia. Officers made contact with the same victim, Najaya Jones, Nyjaya, Jones, Jones. Officers learned during the course of their investigation that there was a verbal altercation that turned physical. The defendant did slam the victim's hand in the door, leaving an actively bleeding gash on her middle and ring finger. Those are the facts of the case, Your Honor. The state's recommendation is 12 months to serve on count 1. Count 2, 3, and 4 will merge. Your Honor, as negotiated, all cases will run concurrent.
All right, Mr. Lynch. You're muted.
Judge, that was my understanding. A couple things to point out about my client. He's 25 years old. He has 3 children. His entire criminal history, other than perhaps traffic offenses, consists of charges with Ms. Jones. I don't say that to say that that makes it okay. I just, other than this relationship with Ms. Jones, my client does not have a history of violent offenses or serious criminal offenses of any kind. We had discussed potential defenses in this case. However, the recommendation from the state is what he ultimately decided to do. He has been in custody since November of 24. And so, of course, we ask that he gets all credit for time that he served towards this sentence. He is currently on probation out of Superior Court, Judge. And so we would just ask that he be sentenced as recommended.
Is Ms. Jones going to offer a statement?
She's asking if Ms. Jones wants to say something.
Good morning, Ms. Jones.
I'm not requiring it. I'm just asking. She's on, so she might. If she's going to speak, I need to know it before I speak. All right. Does he have the 3 kids with Ms. Jones, or did
No,
he
Judge.
bless somebody else with that?
Not my understanding is he does not have any children with Ms. Jones. That's correct.
Okay. Mr. Dixon, move over, Mr. Lynch. Let Mr. Dixon get closer. Dixon, what in the world? I mean, like, you would think somebody would learn the first time, but you got 4 examples of you and Ms. Jones, and you ended up in jail because you can't keep your hands off of somebody. Like, you are a classic walking to the situation where you're gonna end up killing her and your picture gonna be on the news. Because that's what you're setting up. And you would tell anybody who asked, I love her so much. But to me, love is not beating somebody. Not and catching. Listen to me. 4 cases, 1 felony, 3 misdemeanors, all violent, all with the same person. You either got to be like, really, walk away. You don't have any kids with her. You can't love her because you keep beating her. Walk away. Walk away before one of y'all ends up dead. Walk away. Learn from this. You know, I've been on this bench since 2016. You would be only the 2nd or 3rd person that I have maxed out. The 2nd or 3rd person. Now, whatever your obsession is with Ms. Jones, please understand that when I say this, it's not just going to be 12 months. It's 12 months with no contact. If somebody tells me you got a phone conversation with her from the jail, we're going to have a different conversation. And in fact, I feel like one of these should be run consecutive. So I have a little leeway to play with. You are the 3rd person, maybe the 2nd that I have maxed out. Because you are obsessed with Ms. Jones and you don't have enough sense to stay away from her. You violated 2 bond conditions. You picked up the case in 2024 had a bond condition. Don't have any contact with Miss Jones. What do? You have contact with Miss Jones. The first case in 2025, bond condition. What does it say? Don't have contact with Miss Jones. What do? You have contact with Miss Jones. So whatever your obsession is with Miss Jones, you got 12 months to get over it. 12 months. Do you understand? Are we clear?
Yes, ma'am.
No, I need you to speak up, sir.
Yes, ma'am.
Because you're about to spend 12 months in jail because you don't know how to listen. You're about to spend 12 months in jail because you're obsessed with somebody and you don't know how to communicate. You're about to spend 12 months in jail because you think it's all right to pick somebody up and throw them. You're about to spend 12 months in jail not providing for your children, not seeing your children, not being a help to the person who is raising your children because you're so obsessed with Miss Jones, you can't stop. Sir, everything that you think is good for you ain't. If it's good to you, it might not be good for you. Are we clear?
Yes, ma'am.
Don't be dumb. Don't be dumb. Because, see, you got this little obsession thing going on, and you think just because afterwards you can say, well, but I love her so much. This is not love. This is obsession. Anybody who risks their life, who risks jail time, and this is not, let me just between me and you, this is not the best time to go to the Clayton County Jail. It's not. The sheriff himself has said they are understaffed. The sheriff himself has said it is dangerous in the jail. The sheriff himself has said that they only have a few COs and deputies who can watch you. So anything can happen to you in the pods. They have already got cases of extortion, murder, aggravated assault, all stemming from the jail. This is the worst time for you to go to the jail, sir. I hope I'm making an impression upon you that your obsession with Miss Jones is going to put you in jeopardy because you got to go to the jail now for 12 months and make your way. Tell me what are you thinking, Mr. Dixon? Tell me why I'm sitting here looking at you with 3 cases and a felony that's already been adjudicated.
We're still here. It's screen's up.
I'm listening.
Can you repeat that for me, please?
At 25, why are you willing to risk your life and repeatedly go back and have contact with Miss Jones?
I wasn't learning that first.
You what?
I wasn't learning that first.
Oh, okay. Because, see, your cases came so quick. They didn't get them to me quick enough so I could revoke that bond. Because I might have been able to stop Miss Jones from getting beat the 3rd time. You was racking them up back to back to back. And I don't know if you think this makes you a big man because you can put your hands on a woman. But as I said, you're putting your hands on a woman. That's the least manly thing that anybody could do. Unless she's an MMA fighter, she ain't competition. So you putting your hands on a woman, that ain't manly. Not at all. That's a punk move. I'm just saying. We clear?
Yes, ma'am.
You go into the jail with that kind of energy, you ain't gonna survive. So I just want you to know, sir, do not play with me. We clear?
Yes, ma'am.
Okay. Go in there, do your time, get Miss Jones off your mind. Do not let me so much as hear a phone conversation. We clear? Or else I'll be talking to the people about your 5-year probation on your felony probation. I'll be writing a letter to that judge. I can do that. Who was he in front of?
Scott.
Oh, nice Judge Scott. Nice, Judge Scott. But when I explained to her how you are obsessed with Miss Jones, and even though I told you not to bother her, you bothered her again, I'm sure that nice Judge Scott will be firm Judge Scott and she'll give you the 5 years in prison. We clear?
Yes, ma'am.
Please don't, please, I'm begging you. Get Miss Jones off your mind. One phone call, that's all it's gonna take. You have one jail phone call with her, and I'm writing a letter to Judge Scott. If nothing else, to save Miss Jones's life. We clear?
Yes, ma'am.
And ask your lawyer if I'm serious, because he's been with me a long time. He knows just how serious I am. If I say it, I'm gonna do it. All right? So you just go to that jail and be lovesick, but do not reach out to Miss Jones. I'm going to accept your plea in each of these cases, your guilty plea. I'm going to sentence you to 12 months to serve on the case ending in 02178. Count 2 will merge with count 1. I'll sentence you on case 2025 CR 00537 on count 1 criminal trespass, 12 months to serve. Count 2 will be no pros on case 2025 CR 00546, 12 months to serve. Counts 2, 3, and 4 will merge. These cases will all run concurrent with each other. But if you mess up, if I hear even about a phone conversation, I'm writing a letter to the judge who is over your 5-year felony probation. We clear.
Yes, ma'am.
All right, you can go back with the sheriff's office. You're gonna be there a while.
Judge, just to make sure that, I know we've discussed this, but that it's credit for the time that he's already served.
We had this discussion. I'll give him credit since the date of lockup. But how the sheriff counts it, that's up to him. And the sheriff told us he has about 237 murderers and 750 people who've been accused of attempted murder in the jail, and the jail is overcrowded and understaffed. So there you go, Mr. Dixon.
Thank you, Judge.
You're welcome.